Welcome, everyone, to Unsafe Space. You are watching a special weekend edition of Dangerous Thoughts. I guess that's what we can call it. I'm your host, Carter Laren. As I mentioned on Wednesday, which is when Dangerous Thoughts usually airs, I'll be out for the next couple weeks. So I figured I would take this opportunity to briefly talk to you about two important back-to-back Supreme Court decisions that just happened Thursday and Friday, and that way you get a little bit of Dangerous Thoughts while I'm gone. All right. Insert all of the marketing stuff here. Visit unsafespace.com to support all the series. Like, share, blah, blah, blah. Okay, let's talk about the two decisions. You know, one of the reasons I wanted to talk about these two is maybe not everyone is understanding exactly what's going on. And, maybe for some of you, this is remedial. In that case, you can share this video with your friends for whom it's not remedial. But, my wife brought this up this morning. I often put NPR on in the morning in the house because I'm a sadist and or maybe a masochist. And NPR today they were losing their marbles over both of these decisions, which I think just reveals how unprincipled the Cathedral is, or as I was referring to them on Wednesday as the first and second estates. If you don't get that reference, go watch Wednesday's show. But they're really going crazy over this. It's kind of like the January 6th hysteria, right? It's an insurrection, blah, blah, blah. So, my wife, who did not grow up in the U.S., as many of you know, she asked me at the breakfast table this morning, hey, what's going on? I'm hearing that she heard, this is what through the grapevine she's hearing. I'm hearing that now abortion is illegal everywhere in the U.S. and that people are going to start shooting each other. That's a thing now. People are going to start shooting each other, and everyone's going to have a gun. Not that she cares too much about. She's not opposed necessarily to everyone having a gun. She just was like, "This is what I'm hearing. What's going on?" So I thought, okay, well, let's take a look at this. Now, as a reminder, when we look at Supreme Court rulings, we're looking at what's legal. We're trying to do a rational, objective interpretation of the U.S. Constitution. That's what we're trying to do. We're not trying to make a moral decision necessarily. Now, I think it's important. I mean, most of what I talk about is philosophy, culture, and as a result, ethics and morals. So it is important to make distinctions, right, when we see that, oh, this thing is immoral. But when we're talking specifically in the context of Supreme Court rulings, we have to accept a framework that I know not all of us might agree with, which is there is a United States. There is a Constitution that governs the United States, and we are supposedly following this Constitution. And so that's how we look at these rules. So, most people, though, they tend to look at a Supreme Court ruling, and if they like the moral outcome, then they love the ruling. And if they dislike the moral outcome, then they don't like the ruling, which is not an honest way of evaluating Supreme Court rulings. It's sophomoric, it's childish, and you should be ashamed of yourself if that's how you evaluate Supreme Court rulings. You don't have to be a lawyer, but the way to evaluate, because I'm not a lawyer, obviously, but the way to evaluate these is, the honest way to evaluate these is to ask yourself, well, is this ruling constitutional? Do I think that based on the plain language of the Constitution and the meaning of the words written at the time, this ruling is correct? If I still don't like it, then you have other options, right? You could say, well, I think the U.S. Constitution should be changed, or I think, or this is a case where even though I think some immoral stuff is allowed, I got to understand that illegality and immorality ought to not be the same thing. We can't conflate those. And so this is just a case of something I don't like being allowed or whatever. And and move on with your life. So conflating I like this with this was a good ruling is, like I said, it's childish at best and dishonest at worst. And I think most of the left is dishonest with respect to this. So Thursday, let's talk about Thursday's ruling first. The Supreme Court, I think this opinion was written by Clarence Thomas. The Supreme Court ruled on the Sullivan Act. Now, I don't know if it was just the Sullivan Act, actually, but basically the Sullivan Act in New York. I first learned about the Sullivan Act from reading Mickey Spillane novels. It's pretty widely known in New York, and it's a gun control law back from like 1911. Coincidentally, when the Army adopted the 1911 handgun as its standard. It's old. It's over 100 years old, and it basically says you need a license required to concealed carry. And like many laws in many jurisdictions, it is a may issue law, and that's not uncommon. Here in California, we've got a lot of may issue laws, and the difference between when someone says may issue, they're contrasting it with shall issue. There are shall issue laws in states, and those laws say if someone applies for there are states unlike Vermont where you don't have to have any, there's just constitutional carry, you can just carry. I'm pretty sure that's still the case in Vermont. Many states want to have some sort of licensing requirement, but they recognize that this is a Second Amendment right, and they can't really prohibit you unjustly from having a concealed weapon, so they have a shall issue clause, and they basically, it's a way for them to say, well, unless the local police department, who's usually in charge of issuing these, sometimes it's the sheriff, but unless the local police department, actually I think it's often the sheriff, unless they say, hey, we found this reason why you shouldn't, like, for example, you've been convicted 17 times of assault and battery or something, like we found something, you're a felon, whatever. We found a reason, you were convicted for murder and you're out. Like, we found some reasons why we think you shouldn't have a weapon. Now you can argue that those reasons shouldn't be allowed, and that's a separate discussion. But shall issue states generally have this rule that, look, if someone applies, you got to give it to them. Maybe you have to make them jump through some hoops, like they have to take a class. But in general, you got to issue unless there's a compelling reason to not issue. May issue laws are the reverse of that. They basically say, well, it's up to the local police. As I said, I think it's often the sheriff, although I'm not sure. It's the sheriff here and in many other places. And this basically gives the local law enforcement complete discretion. They may issue a carry permit if they want to. But they don't have to. And in California, you get, and the same as in New York, you get a variety of different implementations of this. So I was friends, before he passed away a few years ago, I was friends with the district attorney of Mendocino County. And up in Mendocino County, he would, they would issue permits to anyone who wanted a concealed carry permit, right? Even though it's California, you applied, you got one. I think if you got caught, if I recall, I taught some concealed carry classes for him up there, and I think the reason some people were in the classes was if you got caught carrying a weapon without a license, his punishment for you was you had to get a license, take a class. So he's, pretty libertarian. His name was Norm Vroman. Great guy. But of course, in other counties, down in San Francisco County, Santa Clara County, Alameda County, these other counties that are surround the city of San Francisco, Oakland, and San Jose, these counties, it's much different. Almost no one can get a permit. In fact, I think several years ago, it's been a while, so these numbers are not correct, I'm sure, but several years ago, I remember looking into this and reading something about there was like 6 permit holders in all of San Francisco County. And it was people like Nancy Pelosi. I mean, I don't know if it was her, but it was like those kind of, it might have actually, no, maybe it was Barbara Boxer. It was some politician. There's like 6 people in the entire city, in the entire county who were issued permits. And of course it's because they're well connected, and the local law enforcement decided that they had a justification for having a firearm. So that's what May issue is. And New York was a May issue state because of the Sullivan Act. And in many jurisdictions in New York, particularly New York City, which obviously is where a large percentage of the New York population is in and around New York City, you had to justify yourself to the local police. You had to have, quote, proper cause. Proper cause means whatever they want it to mean. Usually it's pretty strict. It's like, well, you're a security guard who's protecting politicians that we like. Okay. Or you're the DA, or you're an ex-cop. The cliche example in New York City was you're a diamond merchant and you carry around diamonds. It's like, all right, well, maybe, but most people aren't diamond merchants or ex-cops or DAs, so they don't get permits. And just like San Francisco, it was nearly impossible to get a concealed carry permit. It is nearly impossible to get a concealed carry permit in the city of New York, as well as many other counties around New York State. So here's the ruling. Let's just read the ruling. Again, written by Clarence Thomas. The beginning is just a summary. I'm going to read the summary so you guys can hear instead of my botched description of the law. Here's what the summary says. The state of New York makes it a crime to possess a firearm without a license, whether inside or outside the home. An individual who wants to carry a firearm outside his home may obtain an unrestricted license to, quote, have and carry a concealed, quote, pistol or revolver if he can prove that, quote, proper cause exists for doing so. New York penal law, blah, blah, blah. An applicant satisfies the, quote, proper clause requirement only if he can, quote, demonstrate a special need for self-protection, distinguishable from that of the general community. Now, this language is interesting, right? Because it means regular people actually don't have, they're very, very clear. Regular people don't have the special need. You have to demonstrate that you have a need that's distinguishable from everyone else, which is why you end up with, hey, do you carry around millions of dollars of diamonds on a regular basis? Okay, fine. So that's the summary of this. That's the very beginning, which just describes the situation, and then we'll skip down to the opinion, where Thomas writes, we too agree and now hold consistent with Heller and McDonald, which was a previous Supreme Court ruling, that the Second and 14th Amendments protect an individual's rights to carry a handgun for self-defense outside the home. A little further, he writes, because the state of New York issues public carry licenses only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regime violates the Constitution. Cue NPR pearl clutching, hysteria, fainting on the couch, and saying, oh my God, everyone's going to die in the streets now. That's the ruling. So that was Thursday's ruling. They're already queued up about that. So, but I'm recording this on a Friday, though, although I expect this will go out over the weekend. And this morning, they were in the middle of hysteria over this ruling when suddenly, in real time, the Roe v. Wade ruling came out, and they had to switch gears and faint over something else. So today, when I'm recording this, the Roe v. Wade ruling, which was written by Judge Alito, that we all saw coming. Obviously, it was leaked, right? This was the one that was leaked, that was in the news extensively the past couple months. This ruling was finally released, and I don't know how different it is. I haven't read the entire thing. It's long. I don't know how different it is from the original, but the conclusion is the same, which is that it's overturning Roe v. Wade. So, of course, this gets misrepresented. And this is what my wife was asking about, because if you listen to most media and even a lot of politicians that are interviewed on media and whatever, they say this makes abortion illegal. Right? No, this does not make abortion illegal. That's not what it does. Let's just quickly remind you guys what the Roe decision was. And by the way, I talked about this more extensively in a previous episode. I think it was, I don't remember. I don't remember. Actually, here, let me look up the name of it. I do have the name of it sitting here somewhere. It was called Ministry of Truth. So you look at a previous Dangerous Thoughts episode if you want to get into Roe v. Wade a little bit more. I'm not going to get into it too deeply right now. But what the Roe v. Wade decision was, this is a 1973 Supreme Court case in which they ruled that the Constitution protects pregnant women's rights to abortion. They also said it wasn't absolute. So not only do they see abortion somewhere in the Constitution, they apparently see the nuances of trimester-based litmus tests all in the Constitution. I don't know where it is, but they saw all that in there. And so in Roe v. Wade, they said, well, they implemented this, like I said, trimester-based structure where they said, well, in the first trimester, states are not allowed to regulate it at all. And in the second trimester, they're allowed to regulate it, but only for the purposes of protecting maternal health. And in the third trimester, they can regulate it or prohibit it or whatever. Now, in 1992, there was another Supreme Court case called Casey, which actually overturned parts of Roe, but not in the same way. They basically replaced this trimester thing with a viability analysis, because that's clearly in my pocket Constitution. I think there's a whole section, right? Who was it? Madison, who wrote all about the viability of fetuses somewhere. Anyway, they found that in there, and that was the ruling. So we've been living under a combination of Roe v. Wade and Casey for the past couple decades. And obviously some states restrict later term abortions more than other states. Here in California, it's relatively lax. In other states, it's a little bit more difficult. And of course, there are states that want to restrict abortion much earlier and can't because of, or haven't been able to because of the Supreme Court ruling, both Roe and Casey. Now, it's important to see, I'm mocking this a little bit about, hey, where is this stuff in the Constitution? Well, fortunately, when they write opinions, they tell you what part they're looking at. And I've got a note here to myself that says, read it because it's janky. Janky is an official legal term. So I'm going to read, this is my pocket Constitution. I'm going to read, so the justification for Roe v. Wade, not this current one, but the previous one, is that the due process clause of the 14th Amendment is where they see all this right to an abortion and even like viability tests and stuff. It's all here. So if you miss it, don't blink, you might miss it. So I'm going to read, this is in section 1 of the 14th Amendment. I'll read the whole section 1. It's not that long. But I'll highlight the part where we have our due process clause. Okay, section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Now, by the way, this is this is the Reconstruction era. This is post Civil War. That's why they're writing this, so that people can't say like, oh, black people aren't citizens or whatever. So all persons born or naturalized are subject to the jurisdiction. Okay. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Okay. You think maybe that's where they found it, but no, that's not where abortion is. Hold on. Nor shall any state deprive any person of life, liberty, or property without due process of law. That's where it is. It's in there. Nor deny any person within its jurisdiction the equal protection of the laws. So that's, if you missed it here, what that says is women are entitled to abort their fetuses based on viability tests. And I don't know how you can't see that. It's right there. So anyway, that was the justification. That was justification of Roe v. Wade, and That is what Friday's decision, written by Alito and leaked earlier, that's what they've disagreed with. They've said, hey, they don't see abortion there in that clause. I don't know. Maybe they need reading glasses. All right. So let's make sense of these opinions really briefly. This isn't going to be a long show, as I mentioned, because what's most fascinating to me here is the juxtaposition of how the Cathedral, the media, most of the media is reacting to the gun law case versus Roe v. Wade, because they happen here back to back, and it's interesting. On the one hand, here we have the Second Amendment to the Constitution. Now, you could make an argument. Let's just go back to the Bill of Rights here in my pocket Constitution. I'm going to actually read the First Amendment because I'm going to make a kind of a weird point here. The First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. That's all one sentence. Now, if you'll note, it begins with the clause, Congress shall make no law. You could argue that that doesn't say states can't make laws restricting freedom of speech and religion. Like, that could be an argument based on the First Amendment, right? And you hear the First Amendment touted a lot, maybe more selectively now than in the past, given the left's newfound propensity for censorship. But you could read that and make an argument that the Constitution doesn't say, Nevada can't pass a law here to restrict. It just says Congress can't. So you could make that argument. But when you move down to the Second Amendment, you can't even make that argument. Let's read the Second Amendment, shall we? It does not start with Congress shall make no law. It doesn't say that at all. It starts with a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay. So first of all, regardless of what you think of all these, terms we can talk about in a minute, well-regulated militia, regardless of what you think about them, this is much more of a proclamation that there's a right here, whatever that right is. We can argue about it in a minute. There's a right here, and that right shall not be infringed. It doesn't say Congress can't do blah, blah, blah. It says that right shall not be infringed. It's much harder to make an argument about the Second Amendment that states can do something, like states can pass laws, because it says shall not be infringed. Right. So the Second Amendment is actually much stronger from a if you're just measuring in terms of how much power the federal government is attempting or claiming to be able to exert on state self-management and state self-governance. The First Amendment, you could argue, they're not really exerting that much. They're saying they can't do it, but they're not really stopping you. The Second Amendment, they're exerting a lot more forceful power here. So let's just talk about, because people pick on this kind of well-regulated militia stuff. Let's just talk about it for a moment. Well-regulated at the time simply meant proficient, well-practiced, able to train. That's all. It doesn't mean regulated in regulations. That's not what it meant at all. There's no evidence to suggest that's what it meant. There is evidence to suggest that it meant others, like it meant just proficient, well-practiced. That's what it meant. Right. So this is why I often say, the left will be happy to give you the Constitution if they can steal the dictionary, right? If they can rewrite the dictionary, which, I don't know the entire etymology of the phrase well-regulated and where it started and when it started to be used differently. But Certainly, the idea of massive federal regulation was not something that was common at the founding, and well-regulated certainly didn't mean that. We know that when and how this phrase became, meant regulated by the federal government, I'm not exactly sure, but that's their claim. If they can claim that means, if well-regulated means there's lots of licensing and regulations around it, well, that's their claim, right? And then they can, if they do that, then they don't have to change the text. But of course, that's not a proper reading. It's a dishonest reading to do that. Let's also talk about militia, because they love to pick on the anti-gun people. And I'm not even going to call them anti. There are no anti-gun people. There are people who want jackbooted thugs and governments to have guns, but no one else, and people who want gun equity, shall we call it? Let's use one of their languages. I want gun equity or gun equality. Everyone can have a gun. They want only people in power, right? Only the privileged, as they would say, to have guns. So anyway, they will argue, they'll pick on this word militia. Now, they pretend that this militia means something other than what it did. Let's just take a look at history here. James Madison in Federalist number 46 refers to the militia as, quote, now, by the way, James Madison, this is not someone who's unfamiliar with the Constitution. This isn't a guy who's separated by 5 generations and is, working at an NGO funded by George Soros. This is James Madison. He's one of the founding fathers. He's certainly familiar with the Constitution. He writes, near 500,000, this is what he says the militia is, near 500,000 of citizens with arms in their hands. Now, that 500,000 number, you might say, see, he's just referring to a subset. The population at the time, 500,000 was basically all able-bodied men in the entire population at the time. So he was saying the militia is all able-bodied men with arms in their hands. That's what it is. It's all the dudes carrying guns. All right. There's another reference here that I think is worth looking at. There's a guy named, I'm not sure if I'm pronouncing this correctly, but Tench Coxe, Coxe, and his first name is Tench. I don't know if he was born in Hollywood, but I don't think so, because he was from Pennsylvania. He was a member of the Confederation Congress from Pennsylvania. And he wrote a series of essays at the time to explain this. He was trying to convince Pennsylvanians to ratify this new constitution. And he was therefore explaining it to them and saying, this is why we should ratify it. This is what it is. Now, of course, we know that the Constitution was written to be interpreted by laymen. It wasn't designed to require lawyers and explanations, but nevertheless, he's trying to make arguments for it and say, hey, this is what this means, guys. And there was a minority of people in Pennsylvania at the time who were saying that this was giving the, quote, power of the sword. It was putting the, quote, power of the sword in the hands of Congress. They were worried that, like, hey, I don't want to give this monopoly on force to these dudes in Congress. Like, I don't want to give them the power of the sword. And he's explaining it to them. Now, if you're a leftist, you might think he was about to say, no, the states have the power of the sword, blah, blah, blah. Don't worry. That's not how he explains it. Of course, it's not how he explains it, because that's not how it's written, and it's not how anyone understood it at the time. He writes, the powers of the sword are in the hands of the yeomanry. I love that word. The yeomanry, I guess is how you would pronounce it, of America from 16. Oh, it doesn't say 21, huh? From 16 to 60. I guess after 60, you're not allowed. The militia of these free commonwealths, entitled and accustomed to their arms when compared with any possible army, must be tremendous and irresistible. Okay? So he's saying, by the way, this is a nod to, like, hey, we've got to outnumber them and be well armed. And he's talking about outnumbering the federal government, law enforcement, and be well armed. It's the militia. Now, what does he mean by militia? He says right here, who are the militia? Are they not ourselves? It is feared then that we shall turn our arms against each man We will turn our arms, each man against his own bosom. Congress have no power to disarm the militia. Their swords and every other terrible implement of the soldier are the birthright of an American. Let's read this again. Their swords and every other terrible, terrible implement of the soldier are the birthright of an American. What clause in the state or federal constitution hath given away that important right? The unlimited power of the sword is not in the hands of either the federal or state governments, but where I trust in God, it will ever remain in the hands of the people. So, well-regulated militia does not mean Gavin Newsom's California Guard. It never has. It never did. That's not what it means. Now, that said, even if it did, even if well-regulated militia did mean Gavin Newsom's California Guard, that part of this amendment is just setting up the statement of the right. It's just an explanatory clause. Here's the reason, therefore this right shall not be infringed. So it does not, so the part that matters here in terms of implementation is the right that's recognized. So it says, this thing being necessary for this other thing, this right needs to be recognized. Now, if they meant Gavin Newsom's California Guard, they would have written something to the effect of a well-regulated militia being necessary to the security of a free state. The rights of states to maintain such militias shall not be infringed. That's what it would say, right? Here's the explanation. Here's the right that shall not be infringed. But the right that's recognized here is not a state right. It doesn't say, therefore, states can have militias, or even, the right of government agencies to have militias shall not be. It doesn't say that. It doesn't say local governments, doesn't say state governments, doesn't say that at all. It says the right of the people to keep and bear arms shall not be infringed. Now, you cannot like that, lefties. You can think that the Constitution should be different. You can make arguments about it. You can even, unfortunately, probably convince a bunch of other people and maybe even get the Constitution changed someday, which I hope that does not happen. But you could do that. But you can't be intellectually honest. You can't maintain your intellectual honesty, if you have any, and pretend that the Second Amendment means anything other than it's the right of regular people to have and carry around firearms. And not just firearms. I'm going to go back and read this clause from this explanation from Koch's. Terrible implements of the soldier. People have a right to own and carry terrible implements of the soldier. Why? Again, let's go back. When compared with any possible army, the people, basically, must be tremendous and irresistible. That's why. You cannot like it. You're allowed to not like it. You're allowed to say it's immoral. You're wrong, but you're allowed to say it's immoral. You're allowed to make arguments for it, and be taken seriously, at least in a sense of intellectual honesty. But you can't pretend it means something else. So, being upset about the Sullivan ruling, I'm calling it the Sullivan ruling. I think the official title is New York State Rifle and Pistol Association Incorporated et al. Versus Bruin, Superintendent of New York State Police et al. So, you can be upset about that ruling. But if you're going to be upset about that ruling and simultaneously be upset about overturning Roe, you're 100% intellectually dishonest. That's just intellectual dishonesty. There's nothing else there. Which is all of NPR, by the way, right now. And I'm sure CNN, I haven't watched CNN today, but I'm sure other things. Right? Because if that's your position, if you are lamenting Thomas's ruling and lamenting Alito's ruling, both, it means that you somehow, you read the Second Amendment that we just read, and you don't see what's clearly written there. But it also means that you read the 14th Amendment. In particular, you read, nor shall any state deprive any person of life, liberty, or property without due process of law. You read that, and you say, clearly, that means there's a right to an abortion based on viability. You're just a liar and a hack, and you're dishonest if that's all of NPR, everyone with this opinion, you are liars, you are dishonest. There is no room for mistake here. There's no room. I'm not going to be, I'm in a mood here because I am not going to be forgiving. This is not an honest mistake. These rulings are back to back, and you're simultaneously making these arguments. You're either retarded and should not be on the air, or you are dishonest and should not be on the air. You can complain about it. I got no problem with people complaining about it and saying, I don't think this is the way that it should be. It's time to abolish the Second Amendment. I disagree, but at least that's an honest position. I got no problem with them saying, look, well, Congress should pass a law about abortion. Like, I don't agree with that either, but you could make that argument. But to pretend that both Thomas and Alito are misreading the Constitution, you're just dishonest. Right. And there can be no rights to an abortion in the Constitution. I don't want to get into this because I'm not like adamantly wanting to ban all abortion. That's not my stance. But, if you're reading this 14th Amendment and you're magically seeing a right to an abortion, like this makes no sense. There can't be a right to an abortion in the Constitution. There can't be. Why is that? Well, because the issue at the heart of the abortion debate is whether it's murder, right? Because we all already agree that states are definitely allowed to make murder illegal. That's allowed. No one's arguing that, they're not allowed to make murder illegal. They're probably prohibited from making it legal. I don't know. I haven't thought about that question too much, but states are probably prohibited from making it legal. They probably, California can't probably just, say, hey, it's open season on people under 18 and over 70. Woohoo. I don't think they can do that. I mean, again, I haven't actually tried to legally address that question. Obviously, it's immoral, but I haven't tried to look at that from a legal perspective. But I'm pretty sure that wouldn't be allowed, right? So no one's arguing that murder should be allowed. The question at the heart of the abortion debate is abortion murder? Obviously, that's the question. And people who are on one side think, therefore it should be legal. And people on the other side think, therefore it should be legal. That's all. I mean, it's not that complicated. The question is, it is complicated, but seeing what the question's about isn't complicated. It's about whether abortion's murder. That's it. When between the zygote stage and 21 years of old or 60 years of old, does a human obtain the right to not be murdered? When does that happen? Some people say it happens at zygote stage. Some people say it happens at heartbeat stage. Some people say it happens at, brain activity stage. Some people say it happens at birth. Very few people say it happens when you're 21, but whatever. That's the question. And no honest person, this is why this is dishonest, no honest person can possibly pretend that that issue is addressed in the U.S. Constitution. It's not addressed. Therefore, abortion's not in here. It can't be, because that issue isn't addressed, and that's the issue. There is no clause in the Constitution about when rights happen to entities with human DNA. That's not in here. It's not even implied in here. You want to add it, fine, make the argument, but it's not there. And yet you have this entire establishment. You have the media, most corporations, almost all bureaucrats at both the state and federal levels, even local levels. Most activists, not all activists, but most activists, many, if not most federal politicians, the entire cathedral, that entire first and second estate, they are wringing their hands over these decisions. It's complete dishonesty. And you know, over the next several weeks, these people will, if not outright encourage, at the very least, they will tacitly sanction violence in response to these decisions. Make no mistake, we're very likely to see another summer of violence. And, you know, maybe the White House will condemn it a bit publicly because they're in charge, right? They wouldn't condemn it if Trump was in charge, but they'll condemn it a little bit because they're in charge and they don't want that. But, you know, their entire ilk will secretly be gleeful about violence, about this stuff. And they'll do nothing of substance to oppose this. If cities burn, no one will use the word insurrection. Instead, they'll go back to using phrases like peaceful protests. That's what will happen. And we've already seen threats against Supreme Court justices, which have received very little coverage. They suppress stories like that. So, you know, as you watch NPR and CNN and the rest of the cathedral, you know, grow apoplectic over these rulings, please notice, see through it, notice that their outrage is performative histrionics. It's not moral outrage. No matter how many multisyllabic words and deep pensive sighs and hushed tones NPR uses to analyze this, it's nothing more than a temper tantrum over loss of control. That's all it is. That's all it is. There is no possible, rational, honest reason to be pissed off about these two rulings. And look, I didn't like a lot about Trump. I didn't like a lot about his Supreme Court picks, right? But these Supreme Court picks are still the best thing that he's done, that he ever did as president. They're not great. I mean, I'm not a fanboy of Gorsuch or Kavanaugh or Barrett, but these are sound decisions. They're grounded in what appears to be an honest reading of the Constitution for the most part, and they wouldn't have happened without Trump's appointments. So, you know, good for that. So that's all I wanted to talk about. I wanted to bring up those two rulings because, again, like I said, they're back to back, and the reaction is just so obvious to see. You know, one moment this like, how could they not see? How could they not see that abortion is in the Constitution? And the next moment, how could they possibly think that gun rights are in the Constitution? It's just, it would be funny if they weren't in control, if they weren't in power. This would be a comedy. All right, everyone, have a good one. Don't let them burn down your city if you can help it. I will see you on Monday for Narrative Dissonance. As I mentioned, I'm out for Dangerous Thoughts the next couple weeks. If you didn't watch this week's Dangerous Thoughts, I think it's titled Shut Up and Produce. I highly recommend it. I expose the Davos World Economic Forum agenda as you know, they just spoke about it a couple weeks ago in Davos. And I talk about it in a way that I think people will be able to really understand what's the motivation and what they're intending to do, so you can see it when it's getting rolled out. So thanks for watching. Please visit unsafespace.com to support this network, all the shows on it, and I will see you guys on Monday. Take care. Thanks for sticking around until the end. If you're new to Unsafe Space, check out our deep content library that includes discussions with everyone from James Lindsay to Brett Weinstein. And please consider helping to fund our work by visiting unsafespace.com/donate. You can find us on a variety of social media platforms, and you can find a community of like-minded individuals on our Unsafe Space Discord server, which is open to financial supporters at any level. We hope to see you there.
Warning. This is an unsafe space. Dangerous ideas have been detected. The content of this production does not meet WHO health and safety standards. Please report to a United Nations Sanitization Center immediately. Association with the following individuals is strictly prohibited. Experts who benefit from printing money agree that printing money does not cause price inflation. Trust me, just 2 more weeks to slow the spread of monkeypox. If you think about it, no one should be allowed to express opinions. But don't. Think about it, I mean. That's not your job. Thinking has been scientifically proven to be less efficient than compliance. Science, scientific, and scientifically are registered trademarks of the World Economic Forum. Unauthorized use is prohibited. Computer voice courtesy. Never mind, that last line is fake news. Please disregard it and return to your safe space immediately. There will be cake.